learned something, could get $1,000. I was like, oh my God.
I had to come before the end of the night.
Wow. Oh, I see.
There was time here.
It's like, oh my gosh.
Right, I think we're ready to get started. Hello, everyone. Good morning, and welcome to the Journal of Law and Contemporary Problems Conference on Odious Debts and State Corruption. My name is Ann Hazlett, and I am the Editor-in-Chief of Law and Contemporary Problems. And I am pleased today to welcome our panelists, our moderators, and our guests for this discussion on the timely and important topic of odious debts. For over 60 years, Law and Contemporary Problems has been publishing cutting-edge work on the most significant topics of our times, and we continue that tradition today with our discussion here. And we're honored that so many of you have joined us for our symposium. As you know, the journal will publish 2 issues dedicated to this topic in our current volume. Just a note about logistics, please note that there will be 2 panels this morning and 2 panels this afternoon, and there will be a break in conference activities from about 12 o'clock to 1:15, and we'll resume the conference again at 1:15 this afternoon. Let me take a moment to express thanks to those who made today's symposium possible. First, many thanks to our very generous co-sponsors, the Global Capital Markets Center, the Center for International Comparative Law, and the Law School. Thank you, too, to Professor Mitu Gulati. With the help of Lee Buchheit, Professor Gulati brought together this exceptional group of scholars. Many thanks also to Belfer Smith. Finally, a very special thanks to Kimberly Beatty, who put together every detail of this conference. It is with her tremendous dedication and energy that this conference was able to come together. So please join me for a second in thanking her. Please allow me to introduce you to Professor Neil Vidmar, the chair of the Faculty Board of Law and Contemporary Problems.
I just want to welcome you to this issue, the annual conference of Law and Contemporary Problems. Law and Contemporary Problems dates back to 1933 and has long been a flagship journal for Duke Law School. One of its interesting characteristics is its interdisciplinary nature. Arguably the first law and journal, and one of the advantages we think of L&CP is that it's online forever now in this day of an internet, and that has some real advantages for you. The unique nature of L&CP is the collaboration between students and with some faculty oversight on these matters. As Ann mentioned, space is actually often at a premium here, and what I can tell you is that when this issue came up, when Mitu first raised it with the Faculty Oversight Board of a double issue, we didn't even hesitate. There wasn't any debate whatever. We thought that this was an important topic and immediately approved it. I do want to mention that my role, especially with this issue and some others of L&CP, is really sort of a titular head, and the real powers behind for these articles are, first of all, you, the people who are writing the papers, and second, Joan McGott. Is Joan here yet? She is the general editor of this, and she does a lot of the go-between, and she'll be someone who'll be in contact with a lot of you over this, and Joan will show up today, but I do want to give her great credit for what she's doing, and something that someone you'll be working with, and of course Ann, and all of the student editors of L&CP. Those are all the comments I have. I'm happy to welcome you here on behalf of Duke Law School and the board of L&CP. And Mitu did ask me to comment about the format for this today, and that is that you really want to have a discussion rather than the formal presentation of papers. And you all have microphones which operate quite nicely, so you can sit at your desk and ask the questions. And I understand that the panelists will be doing just brief presentations and then open it up for discussion so that there's a full-fledged discussion, and that will come out in the thing. So those are all the comments that I have, and once again, welcome.
Law and Contemporary Problems is very grateful for the support we've received from the Global Capital Markets Center, the co-sponsor of today's conference. So many thanks to Professor Holland West, the Executive Director of the Global Capital Markets Center. Professor West?
Thank you. I'm very much of an interloper here, only having arrived in the last couple of weeks. But I want to thank everyone involved for including the Global Capital Markets Center on this very topical matter. It's a real privilege for our center to be associated with this topic and with the impressive roster of speakers today. For those of you who don't know about the Duke Global Capital Markets Center, it is a unique collaborative center of study and research run by the Duke School of Law and Fuqua School of Business. We pursue our mission through an interdisciplinary approach to finance, business, legal, and public policy issues. Having somewhat recently retired from Sherman and Sterling in New York, I worked somewhat tangentially because my specialty is in another area, but I worked with my partners on various matters involving emerging and third world debt, issuances, defaults, meltdowns, restructurings, workouts. So today, this topic obviously is of enormous importance, not only to the practice and principles of international law and foreign relations, but also to the proper functioning and stability and integrity of the world's capital markets. So I and my colleagues look forward to the dialogue and the thinking that will go on today. Thanks very much.
Today's discussions will be moderated by two of our distinguished guests. Mr. Lee Buchheit of Cleary, Gottlieb, Steen, and Hamilton in New York will moderate this afternoon's discussions. Mr. Buchheit's practice focuses on international and corporate transactions, including sovereign debt management, and he currently represents the government of Iraq in its debt restructuring. So welcome, Mr. Buchheit. Could you welcome? Our first two panels will be moderated by Professor Daniel Tarullo. Professor Tarullo teaches at the Georgetown University Law Center and is a non-resident fellow at the Center for American Progress. He formerly served as the Assistant Secretary of State for Economic Affairs during the Clinton administration. So please join me in welcoming Professor Tarullo.
Thank you, Ann. So I was trying to figure out why Me Too had asked me to co-chair this conference. As I'm going to explain in a moment, I don't purport to have expertise in the area of odious debt, but I do have expertise in keeping people's presentations short. And so I guess it was that government skill which Me Too was most interested in importing here this afternoon. Now, I'm going to just say a few things about my reactions to the papers, not just of this panel, but of the whole conference, and a little bit just to the topic. As I read through the papers and read some other background things that I had seen in an earlier paper that Me Too had done with a couple of co-authors, it seemed to me as though I was looking at a Venn diagram. And although we don't have a board here, if you just conceptualize the Venn diagram, the two intersecting circles were debt overhang or excessive debt for developing countries was the one circle, and the other circle was corruption and the proceeds of corruption in these same countries. And the area of intersection, I thought, was the odious debt slice. And so my first question, thinking in policy terms about it, was how large that slice actually is of intersection. That is this mostly an issue about debt generally? And there's this interesting historical doctrinal strand of odious debt, or thinking about debt as odious, which gives an entree into a larger set of issues. That's one way of thinking. And on the other hand, is a lot of what is being characterized as odious debt with the implication of some measure of conversion for personal use by the ruler of a country. Again, thought of in policy terms best as a subset of the general problem of corruption and conversion of resources and sending your resources to Swiss banks and the like. My reactions were, if it is a small slice, then, again, just coming at it from the outside, and I'm interested to hear what people have to say today, then I wonder about the utility of trying to construct significant doctrinal innovations and or institutions to address that problem alone. That is, my thought was, aren't we in a classic rules principles or rules standards moment where a relatively small number of cases, each of which will have very complicated facts that have very different implications, seems to create a major rulemaking problem, the cost of which may not be worth it given the universe of cases you're looking at. On the other hand, if it's a fairly big set of cases that's in the middle, then I begin to wonder whether those two circles, where the part that doesn't intersect, actually are better entrees into the policy side of the problem. And that gets to my next point, the role of politics. I think it's inevitable that politics in smaller and larger senses play an enormous role in both of the problems that I defined as the big circles and certainly as the intersection of those two. I engaged briefly in the thought experiment of how some elaboration of the doctrine of odious debt would help us sort through the current Ecuador situation, for example. I also tried to figure out which countries in the world, if we took it to a vote, say, of the UN Security Council, would end up being identified as odious, given the vetoes that exist in the UN Security Council. I came up with a null set, but I could be wrong about that. I could be wrong about that. So with politics coming in at every moment, it does seem to me as though we have got to keep coming back to how any institutions in practice would function were they to be given the kind of charges which some of the paper writers would like them to have. Final introductory comment. I was also reminded in reading all these things of all the stuff that was written and some of which I wrote, and that we all read 7, 8, 9 years ago in the wake of the Asian financial crisis, when proposals for big institutional change for sovereign debt restructuring as such were very much current. And there were many, many conferences and many, many panels and many, many books written on this topic. In retrospect, I think we all have to get a little bit of modesty. I know academics are not good at modesty, but we have to get a little bit of modesty about the way in which we all perceive things at the time. And if you look at Argentina, if you look at what has happened in and around and to Argentina and what's happened in the world, one doesn't, I think, see one's own predictions and fears of 7, 8, 9 years ago in many instances measuring up particularly well. And I'm now more convinced than I was at the time that the creation of a big new institution or putting on a new function for the IMF or some other group of wise people would have been a significant mistake, and ironically, a mistake that probably would have redounded to the detriment of the developing countries rather than to their benefit. Who knew that there would be such a compression of spreads around the world today, which has reduced so significantly the borrowing costs of emerging market countries, notwithstanding Argentina's default a few years ago. So with that general set of ideas or questions, again, from someone relatively untutored, I'm going to turn now to the first panel. And it's more of a task than I am up to actually characterize all these papers as developing off of a single theme. But I think there are some threads that, now moving to the other. I think there are some threads that do run through the papers that that the authors at the table have written for the first session, in accordance with what Ann and Me Too instructed me very clearly yesterday and in emails before that. We're going to begin with genuinely brief presentations, comments really, by each of the panelists. I then will put a couple of questions to at least some of the panelists who may want to talk to one another, and then as quickly as possible, as Professor Vidmar said, we'll try to bring all the rest of you in as well. So I have somewhat, or perhaps very arbitrarily, created my own order in which I'm going to ask people to make comments, and just so that everybody knows the order I'm going to have, I was going to ask Jim Feinerman, and then Kim Fielding, and Tai-Heng Cheng, and then Shari Spiegel, and then Anna Gelpern. Okay, so Jim.
Okay, well, I guess I have this injunction to be brief, and I will try to be so, but I'll start with what I hope are two quick quips. One is, to paraphrase a famous statement of Henry Kissinger's, at least one attributed to him, he once said that Brazil is a country of the future and always will be. And whether or not that's proven true, I think it's fair to say that odious debt is the topic of the future and maybe always will be, for some of the reasons that Dan's already articulated. The other is that this sort of rapid-fire attempt I'm going to make to characterize an overview of my paper is somewhat reminiscent of an old gag on the Smothers Brothers show, if anyone remembers that, where their guitarist, Mason Williams, played his song Classical Gas, and they, rapid-fire, showed about 1,500 years of famous Western art, and then Henry Gibson came on in that inimitable voice of his and said, "You have just had all the world's great art indelibly printed on your brain. You are now cultured." I can't say that you'll, after this, know everything there is to know about odious debt, but I've attempted in my paper to provide an introduction to the concept in a slightly retitled form, what I call a legal intellectual history of an idea. So it briefly introduces the concept. I go a little bit through the history of this that starts actually with the United States, interestingly, in the Spanish-American War and the aftermath, where the doctrine was first evinced, although not necessarily using the term odious debt, as an excuse for Cuba not having to pay off loans that were undertaken when it was under Spanish domination. And it's been around in this form for about 100 years. The term odious debt was coined by a Russian emigre in Paris in the 1920s, A.N. Sachs, and used by him and others as some of the explanation as to why a communist government that succeeded the Tsarist rule might renounce that debt. There was even a case involving the only man to ever be president and Chief Justice of the United States, William Howard Taft, as the author of the opinion, in a case involving Costa Rican debt in the U.S. Supreme Court. But it's primarily been a kind of contested concept in the middle of the 20th century by socialist regimes as revolutionary successors to non-socialist and non-revolutionary regimes. The illustrative case I cite in my piece is a case that got me started on this when I was a lowly associate at Davis Polk, Jackson versus the People's Republic of China, that involved Chinese railway bonds, actually not of the predecessor government, but the dynastic government that fell in 1911 was succeeded by the Republican government that fell in 1949 to the communists. And this case was brought on the heels of Jimmy Carter normalizing relations with China in 1979. Speculators, and this is often the case with some of the other odious debt that we may be discussing today, bought up this debt for pennies on the dollar and then decided that with recognition they had a chance to cash in. The 11th Circuit decided otherwise. Just to very quickly give you a glimpse of the international law analysis, there are two conflicting doctrines. One, the idea of rebus extantibus, that things should remain as they are, and that if there are binding commitments by predecessor governments, a change in government, although maybe not a change in regime, shouldn't be a reason to renounce commitments that were made by a prior government. On the other hand, the revolutionary successors claim that they're not bound by the agreements that were made by prior regimes, and the odious debt concept is used to bootstrap the idea that because of the revolutionary change, they no longer have to do what a prior government committed to do. And then it's gone through cycles, and later panels today will discuss this, Starting back in the 1970s, Walter Wriston, the former chairman of Citicorp, made the famous comment that he liked lending to governments because governments never go bankrupt. But as people who have dealt with debt workouts for succeeding regimes can tell you, that's maybe not strictly true. It's true literally, but they do default, and that leads to other problems. And then it was revived in the 1990s, actually, by a number of things, including the run-up to and then the aftermath of the war in Iraq. Joseph Stiglitz wrote an article in the Atlantic Monthly, actually, reviving the term odious debt, and then two economists at the World Bank IMF complex, Kremer and Jayachandran, actually proposed creating a kind of international organization that would act as the final arbiter of whether or not debt was odious and decide whether commitments that were previously made would have to be fulfilled or not. There also was, around the turn of the millennium, the sort of Jubilee 2000 movement, which, drawing on the biblical Jubilee, had the idea of a sort of one-off, one-time only forgiveness of debt for heavily indebted poor countries. And that may be the topic that I want to close my presentation with, and just say that I think that, I was talking to Anna Gelpern about this before we started this morning, her title about odious, not debt. Mine is sort of the opposite, you know, that it's debt but maybe not odious. The problem is, and I say this at the beginning of my paper, all debts are odious. Countries that owe money don't want to repay, and that's understandable. And sometimes they don't want to repay because they're poor, because foolish predecessor regimes undertook commitments that they should have known were going to be difficult to fulfill. But that may not be a reason enough to declare that debt to be odious if the concept's going to have any meaning. This may explain Dan's puzzlement as to why people are talking about this when it doesn't seem to be much applied in actual practice. And it also creates problems of a slippery slope, because once you open the door to the possibility of declaring some debts to be odious, it seems that every debtor is going to find some way of characterizing their country's debt as odious as a way of trying to get out from under. That's not to say that some debts may not truly be odious in the original sort of doctrinal formulation. But it's going to be a very difficult process of separation, and it's also going to be characterized as politicized, because things that your friends owe that you don't want them to have to pay, like Iraqi debt in the US view, is going to be characterized as odious, but things that regimes that you don't like some of the leftist regimes in Latin America that are promising to renounce their debts as odious, passe Ecuador, we're not going to accept as odious, and what's the standard that we're using to do that?
Okay, thank you, Jim. Kim.
I'm actually going to take us back a little bit. Jed and I wrote about trusteeship through the ages with sort of a focus on the mandate system and the post-League sort of historical developments. And he's not here, so I'm not going to do the through the ages part. I'm just going to do the League of Nations and what happened after the League of Nations, which I think is useful to the debate over odious debt in three ways. First, it's a historical precedent for importing private law concepts into the public law arena and using them to judge the legitimacy of a regime. Second, it sort of offers a loose outline of what rights a government owes to its people and to the international community in general. And third, the political landscape is complicated now, but it was just as complicated back when the League of Nations was formed, and so I think it sort of shows the continuity of what can happen in a complex world. So a little bit of background. After World War I, as you guys probably know, all the victorious nations got together, divvied up all the colonies, and they created the League of Nations. And the article that they used in the covenant was Article 22, which talked about a sacred trust, which would be exercised by the advanced nations on behalf of the League. And it sort of has three aspects to it. First, that the population of the mandate are the potential sovereigns. Second, that limited sovereignty belonged to the mandatory power, but it was checked by duties to the international community. And those duties were an acknowledgement of the inherent obligations sort of to the League and to the international community. And these duties had precedent in international law and sort of international politics before this. Westlake argued about guardianship and sort of stressed an equated civilization with competence for self-government. The Berlin Conference talked about all the powers binding themselves to bring home to the natives in Africa sort of the blessings of civilization. And even President McKinley in the Philippines in 1900 talked about an unsought trust that had been placed in the US. So these had sort of, the League of Nations language had precedence in the international community. And the language of Article 22 sort of echoed and modified those concepts. So it talked about the mandate and trusteeship and tutelage, all of which sort of form a general concept that the mandatory power owed duties to its people, but those duties were limited and they were defined. And the population had an interest in good government, and that interest was enforceable by the international community in the form of the Permanent Mandate Commission. So the Permanent Mandate Commission was the advisory body to the League of Nations that sort of looked at all the mandatory powers, what they were doing, and checked them when they were doing something wrong. Obviously, they didn't check them too much because they didn't really have any enforceable power. It's sort of like the UN. So what we did was we looked at all the Permanent Mandate Commission minutes and sort of looked at how they operated. And in practice, what jumps out most is the Permanent Mandate Commission's caution. But it's also worth looking at what they actually rebuked the mandatories for. So there were allegations that the mandatory was profiting from mandated territories. So in Tanganyika, for example, the British were giving favorable postal rates to letters that were going to British territories, and the council sort of warned that they were going to watch this very carefully. And they also warned that they would be watching what maybe we consider human rights violations now. So when Palestinian Jews submitted a long petition talking about how they were upset because they had to work on national holidays and they had to work on their religious holidays, the Permanent Mandate Commission said that they were going to watch that very carefully as well. So that sort of shows the outline of what the Permanent Mandate Commission was looking for. Now, the post-League interpretations of private law principles are sort of illustrated by two cases. The first is Southwest Africa. South Africa had argued that its duties towards the international community had ended when the League had ended. And the ICJ sort of didn't brook that argument at all and talked about how the mandate was created as an international institution with international obligations. And there was a sacred trust of civilization, and that trust was outlasted the actual mandate and the actual League. And the second is Nehru, which was in 1989, which was the first time that a trust had actually litigated and sought redress for violation of what the trust power had actually done in that country. And that was settled, but they settled for more than was going to be used for rehabilitation. So it can sort of be seen as a tacit admission of their dereliction of duty. So basically, our argument would be that the Permanent Mandate Commission, looking at the Permanent Mandate Commission, what they did, how they operated, the language that was used to sort of outline the obligations of both the mandatory powers and the League of Nations towards the mandated communities and the international community sort of show a precedent for having an international body that might be able to both check, both look at the legitimacy of regimes and sort of check regimes that are going too far in a direction that doesn't have to do with the well-being of their people.
Thanks, Kim. Tai-Cheng.
Hello. Well, Professor Tarullo very modestly said the reason why you're here is because you moderate panels well and keep us within time limits. That leads me to speculate the only reason why Me Too invited me here is because I tend to keep to my time limits. I'd like to just, in 3 minutes, spending 1 minute on each of the following three headings, which is, let's really look at what the Doctrine of Odious Debt says. So far, we've had two presentations, but no one's actually discussed what the content of the doctrine is, so let's turn to that. And then I'd like to present to you why the doctrine on its own terms actually does not exist in international law. And then I'd like to propose to you an alternative. It is important to remember that the doctrine of odious debt is a doctrine which could only apply in the situation of state succession, meaning that the international legal personality of a state changes. It does not apply in instances of government succession. That's the doctrinal origins of it, and government succession is where there's a change in government without a change in the personality of the state. It is also important to remember, and Professor Feinerman very astutely pointed out, many people claim that Sachs in 1927 was the first jurist to record the doctrine of odious debt. In fact, there is a jurist who came before him who did so. His name was Aristotle. And let me quote from the Boland translation of Aristotle's Politics. Aristotle wrote, "When a democracy takes the place of an oligarchy or despotism, some persons refuse to meet the contracts in hand on the ground that it was not the state, but the despot who entered into them." Now, in this case, Aristotle started with the notion of government succession because way back, millennia ago, there wasn't a conceptual distinction between state and government succession. Once that conceptual distinction emerged, then came along Sachs' argument and the Spanish-American War, which tried to apply that only in the context of state succession. But even taking positivism to be the right lens through which to view this, there isn't sufficient state practice or opinio juris to support such a doctrine or general principle. Let's look, for example, at, and I apologize to Professor Feinerman, the Tinoco Arbitration, at which Chief Justice Taft sat as sole arbitrator. This was an arbitration in which the successor government following Tinoco tried to disclaim Tinoco's debt. There was no state succession in that instance, and so this cannot be empirical evidence of the operation of the doctrine of odious debt. If you look at the Spanish-American War and the issues concerning Cuba, there was an event of succession there. It was decolonization. Well, actually, it was colonization by the Americans and then decolonization when they finally agreed to extract themselves out of Cuba pursuant to the Teller Amendment, which leads us to present-day Guantanamo Bay. But in that instance, if you look at the historical records from which most of the writings draw from Moore, he shows that, in fact, that debt wasn't entirely odious. Much of that debt was incurred in times of prosperity for the benefit of the Cubans. Therefore, that example cannot be a classic example of odious debt. Furthermore, if you look at the American congressional statements, they show that the purpose of going into Cuba was not to liberate the Cubans, but really to enlarge American interests. So then we don't see the policy underpinning of odious debt operation, which is to liberate the oppressed, and part of that liberation is to free them from prior oppressive debts. And because time is short, I won't go into all the other examples which don't support the doctrine of odious debt, but instead to fast forward to present day times. If you look at recent state successions, we don't find the operation of a doctrine of odious debt. Successions are so intensely political and so factually unique, which was Professor Tarullo's point, that it is hard to extrapolate generally applicable doctrine. What is needed is a radically different conceptual approach to law, which is one where if we're serious about solving legal problems, we do not just look at the operation of legal rules, but we try and understand how and why actors behave. And in fact, the market today has its own way of dealing with oppressive debts, which is if the debts will debilitate a successor state, then the creditors have an interest in rescheduling or renegotiating that debt to make sure that state doesn't fail, because the consequences of state failure reverberate across the capital markets. We saw that in the Iraqi debt renegotiations, at which the term odious debt was initially thrown about, but in the final rescheduling documents appears nowhere. I say this at my peril because I know someone in our audience was intimately involved in that renegotiation and look forward to being corrected on that point. But the cancellation of 80% was not based on the doctrine of the debt, was not based on the doctrine of odious debt. You look at Yugoslavia, renegotiation was again not based on any doctrine of odious debt, but on a pragmatic accommodation of creditor and debtor's interests. Look again at the Soviet Union, when Russia accepted all of Soviet debt, but again subsequently renegotiated on a pragmatic accommodation of the interests of both sides. Time is short, so I will end there as an aperitif to a more in-depth discussion of my proposal.
Okay. Thank you, Tai-Heng. Shari.
Okay, thanks.
Yep. Yes, you do.
Yeah, okay, great, thanks. To take off where we just left off a second ago, when you think about the markets in terms of negotiating debt, I don't think that the markets generally have a way of negotiating when they think that there's a debt overhang, and therefore for the long run, we need to renegotiate the debt. In general, the markets tend to be very short-sighted, and therefore they're not really thinking about the long-run implications of what this debt burden is going to mean for the future growth of the countries. And so when you think about the markets having the solution, it's not necessarily a solution that's appropriate for most of the countries saddled with these debt burdens, which brings us sort of back to the Venn diagram that we started with. In terms of the two groups that Professor Tarullo mentioned at the beginning, the debt overhang groups and the odious groups, and that you have this, the overlap could be the issue that we're talking about. I think that we're talking about actually a much bigger, a different group necessarily than just the overhang group. If we're just talking about the overhang group, then really we're just talking about what do you do with a country that has a debt overhang. And that's not necessarily an issue of odious debt, it's just how do you get a country out of a debt crisis. And in those cases, odious issues might apply to might help us think about the priority. If forgetting about odious countries, but about specific debt issues, then you might think about how do you prioritize the restructuring based on whether the debt was odious or not. But that doesn't necessarily, when you think about odious debt, you really want to take a bigger chunk of the corrupt diagram, which is the corrupt diagram that deals with any debt whatsoever, any debt that had to deal with corruption, and think about how do we write that down in the case of if we think it's odious or not. And so I think that for the Venn diagram in the middle, we're talking, it's a very narrow group, but we're really in the odious debt debate, we're thinking about a much broader part of that second diagram. In addition to that, but I think that the idea of looking at the center part actually is very useful in the sense that the odious debt debate is doing something very important for the broader debt debate, in the sense of getting everyone to focus on the issue of creditor responsibility that hasn't been focused on so much in the issue of what do you do in a debt overhang situation. And from a financial point of view, it's really an issue of risk sharing. How do you get the debtor and the creditor to share the risk of the initial debt? And to think about that more broadly, I want to stick a third circle into our Venn diagram, which may not really be the purpose of this conference, but the issue of illegitimate debt, which is not necessarily odious based on corruption, but is, for example, the case of Norway, which is one of the big cases that we're thinking that's just happened recently, where the debt was not odious in the sense of based on corruption, but was illegitimate necessarily because it didn't help the country. An example, I want to, for an example of that that's even more broad, would be to look at some of the the International Financial Institution loans that Kuniber also talked about in his paper. And going back for a second to Gulati and Buchheit's paper that Professor Tarullo mentioned as well earlier, they gave three cases of a pretend imaginary country that had three cases of debt of situations, and to figure out which of the situations would be odious or not. And the third situation was when the country was just borrowed money and used it to count sand on the beach and completely wasted the funds away. And I want to broaden that for a second to think about the issue of what if, and so the issue was that that wouldn't be considered odious, it was just a stupid decision by the borrower. But what if we had a situation where there was conditionality applied to the loans, and the lender told the borrower that they had to be spending that money to count the sand? And what if, even more so, the lender didn't realize, nobody realized at the time, or maybe some should have realized that by counting the sand, they would be moving it around and causing all sorts of environmental problems for the island. And so an example that would be similar to that would be an example where a country is told to have a foreign exchange policy where they peg their currency, and that they're given loans that are spent defending that currency. And in the end, you have a currency crisis because the currency policy wasn't the correct policy to begin with, and the country is left saddled with debt. And in fact, there's a crisis that comes partially from an inappropriate policy mix. And so the question is, where does that fit into this illegitimate debt situation, and how do you think about who's responsible for that debt in the end, and where the creditor responsibility lies, and how that risk should be shared? It's interesting because when you think about the Sachs definition of odious debt, the first is that it's without the consent of the population, which those loans were done without the consent of the population. The second is that it didn't benefit the population, which we know is true. And the third is that the lender knew or should have known that this would be the case. And so you could argue that in, for example, the IFI loans, the lenders didn't know, but there certainly was a probability that this was the case, that this would lead to problems within, that it wouldn't lead to solutions and could leave the country in situations saddled with debt and possibly even a crisis at the end. And so given that there's some probability, whenever there's some risk or uncertainty as to whether both with odious debt, but even more appropriate for illegitimate debt, as to who knows what, then you have a question of how do you come up with an institutional framework that can share this risk, because there's this uncertainty aspect. And so obviously, the issue of having a legal rule of law is one way to share the risk. So that sets up a framework for risk sharing. Another way is to use financial instruments to try to think about how do you share the risk. And so I just want to throw one instrument in, which would be something like a GDP Linked Bond, where that could be used to enhance, let's say, the rule of law as a separate instrument. And when you think about this, obviously, the idea of a GDP linked bond is that the borrower only pays back the loan if they grow. And if they don't grow or they actually decline, they don't have to pay back the loan, or the interest payments are postponed for the future. And so obviously, this doesn't solve the problem of corruption in terms of odious debt. But what it does do is it does go, starting from the point that I mentioned at the beginning, that the financial markets are very short-term oriented, and even that what it does do is it links ties the lenders, what's the word? It ties lender's interest with the interest of the country for the long term. And so as opposed to so that if you know that everybody's lending to a country and that the country to that extent is that everything is corrupt, all the loans are corrupt, then there's a very low probability that the country is going to grow, and therefore there's very low probability you're going to be repaid on your debt in the future. And so it turns the creditors from short-term oriented to long-term oriented. And it's also something that one can think of as very important and obviously it's very useful for IFI loans to the extent that that if they're going to make a mistake in terms of, in the sense of conditionality, that if the conditionality is wrong, then it also means that you don't get repaid if you made a big mistake in your economic framework. And finally, it's also something that this can lead to Anna's talk, that would be very useful for bilateral loans, where some of the issues are much more complex in terms of how do you figure out what the loan was used for, but that at least you can be tying the results of the loan to the long-term interests of the country. Thanks.
Thank you, Shari. And last introductory comment, Anna.
Thank you very much. Since I'm last, I better be on time. The paper I'm working on for this volume ties in with something I did a couple of years ago, which in some sense fits in better with a lot of the discussion here. That was a paper about the odious debt doctrine, which tried to say three things. First, there is a need for debt relief on moral political grounds, completely apart from economic financial grounds. And David and Patrick talk about that in their paper here. Second, where there is financial economic necessity, the current odious debt doctrine is a lot more trouble than it's worth. It is cumbersome, and it produces less relief over a longer period of time than the conventional financial restructuring mechanisms in place. And third, that this state of the world is far from accidental, and that creditor governments have effectively preempted the emergence of standing regimes and doctrines, be it odious debt or sovereign bankruptcy, in favor of an ad hoc financial restructuring regime which they control. And so the paper here, the second round, builds on that and really goes to the gap between the odious debt doctrine and the odious debt problem. And I suggest that the odious debt doctrine and most of the academic writing about odious debt preceding this volume, which is going to turn the whole thing upside down, addresses a very small, tiny part of the odious debt problem. The doctrine and the doctrinal writing is overwhelmingly about debt owed to private creditors. Creditors driven by, who lend for economic gain and who expect repayment. Okay? And the project tends to be to define the universe of bad debts, odious, malodorous, you pick your word, and figure out how to make that debt unenforceable. Right? That's the bulk of the literature. But the vast majority of the debt owed by the countries cited in that literature is owed to totally different creditors, not private creditors driven by economic gain, but governments. Iraq is a fabulous example. 1/6 of its debt was owed to private creditors, and coincidentally, perhaps, thanks to Lee's efforts, it is the only category of debt that has been, it's done reduced, 80%. Everything else, government-to-government debt, is chugging right along on a 3 to forever year schedule. A new twist. There is a rumor going around that should Ecuador decide to repudiate or restructure its debt next month, Venezuela will be the biggest creditor at the table. Right. Totally different state of play. Okay. Now, government debt doesn't really look like private debt, and what I argue is that it doesn't look like debt at all, the way we understand it. But that fact is not really discussed in odious debt literature, nor, surprisingly, is kind of the nature of official debt, government-to-government debt, discussed in sovereign debt theories. Okay. Governments don't lend to make money from the transaction. Okay. They usually lend to gain policy influence, and the influence can be fabulously benign, loans for girls' education. It can be dreadful, loans to oppress, a minority and slaughter people, or they could be, I don't know what, export credits that really, whose purpose is to promote the interests of the creditor country. Example, a private creditor lending to a risky country wants to get out as soon as possible with the largest amount of money possible. A government creditor lending to a corrupt dictatorship may in fact want to stay as long as possible to maintain influence at the lowest cost possible. Okay. Another difference, governments do not enforce their debts in court. They collect or restructure them usually behind closed doors. How do they restructure their debt? Every time public creditors restructure debt, there tends to be a new layer of conditionality. They gain more control over policy in the poorest countries in particular, those that have no other sources of financing, no market access. So the poorest countries end up in this permanent receivership of sorts, not as a result of the original debt, but as a result of successive rounds of debt relief, okay? So if this animal is not debt, if it doesn't look like debt, what exactly is it, and what do you do about it? And the mandate Me Too gave me was to look at domestic law analogies. So I sort of, scoured my law books and looked to a set of doctrines in debtor, creditor, and bankruptcy law that subordinate debt based on the fact that it's not the arm's length transaction that it purports to be. So that's equitable subordination, recharacterization. And because the government-to-government context is so different, it's important not to be too literal here. So I pick on these two doctrines for very basic propositions. First, that in order to be treated as senior debt, the debtor-creditor relationship must have certain characteristics that give rise to the expectation of priority repayment. Okay. And second, to the extent the relationship lacks some of these characteristics, and you can pick those characteristics that can be arm's length commercial lending, or it can be sort of as socialist as I might like it, right? But if it lacks that set of characteristics, then the debt may not be honored in accordance with its terms. And I should probably leave it off right here, but it doesn't, the idea doesn't lead to very specific policy prescriptions. You can go in very different directions, and we can discuss them as we go.
Okay, thank you, Anna. I think we can clear one piece of underbrush away, but I just want to make sure that I'm right about this. So if we can all be legal positivists for 30 seconds, am I correct that no one is making an argument that as a matter of positive law, international or domestic, there is such a thing as the doctrine of odious debt? Yes. Okay. Anybody in the audience disagree with that proposition? Good. Okay, so that one we can clear away.
Okay.
Now, Now turning, I think, to the normative issue of whether a doctrine of odious debt of some sort would be worthwhile as a legal matter. And here, I guess, I wanted to pick up with Anna's comment, which is why I'd asked her to go last. I mean, it seems to me that one can think about the use of law as an ordering device here in one of two, or both of two ways. One is as a definitional matter. You have a rule that identifies what it is that you're concerned with. As I said earlier, you put a lot of effort into trying to figure out why you're concerned with it, and then you try to affect behavior ex ante, and you try to affect the decision-making behavior of some decision-maker ex post by being bound by that rule. The second device is simply to give legal authority to decide to some institution, believing that that institution, all things considered, will make the proper judgment under the circumstances. And I guess, Anna, let me ask you whether, given your views of the nature of the liabilities, if I can put it that way, that are inherent or inhering in these countries, whether either of those legal devices seems to you to make sense. Because I was going to add something else to what you had in your paper. My recollection is that one of the big reasons why the United States, at least, used lending to developing countries was because Congress didn't like foreign aid. And so if you said it was a loan, Congress said, well, that's okay. You can make a loan to the country. You just can't give them any money. But as Anna suggested, there was never an interest in getting the money paid back in any sort of timely fashion. The second question, except when Congress pressured them to do so, and the second reason was budgetary. If you're in a pay-go system, you gotta find a way to pay for the grant or the foreign aid. But if you're in a pay-go system and you make a, quote, loan, close quote, you don't have to worry about it, and then it gets written down over the years, and it's not that big of a budgetary hit. So there's a non-economic, non-political motivation, non-economic domestic political motivation for characterizing these things as debt anyway. Does it make sense to try to do a rule? Does it make sense to try to have an institution which has authority to do these kind of distinguishing?
See, funny that you should ask, because I exploited the essay format to the hilt and said, well, you could go the rule way, you could go the institution way.
Yeah, I noticed that.
Not the purpose of this paper. And so if you went the rule way, you would say, well, today you've got all of these, albeit informal, but rather ritually practiced rules, right? You've got the Paris Club that tends to go first. That's government-to-government debt. Then they have this comparability clause, and then the private creditors go second, right? So one way of doing this would be to just ditch that rule and replace it with a new rule, which is that, just to get totally Machiavellian, private creditors, if you say they're the real lenders, go first. The Paris Club picks up whatever's left over. You could go sort of the Kunibert route and say, the IFIs go overboard. That would be a rule way, right? Another would be the institution way, which is that you've got the 15 criteria of what entitles a creditor to be repaid, including the form of the loan, the motivations, et cetera, right? And someone gets hauled, and the creditor gets hauled before the tribunal, whether it's sort of Jeff King's duty to arbitrate or some trigger, right? And the tribunal decides, right? I tend to be of the rule variety, mainly because I think with you, I'm just an incorrigible pragmatist, but I acknowledge that there's no kind of intellectual or normative asterisk.
Okay. Other comments on, not necessarily just in Anna's context, but on this issue of whether there would be utility in, even though doctrinally, as a positive matter, no one is arguing that there is such a doctrine, would there be utility in the rule approach to the odious debt, or for that matter, odious regime? I know Patrick and David have a view on that. Odious regime approach before we get to the issue of institutions. Or Jim? And nobody? Okay. All right, now I bet you there is some view in the audience that it would be useful to do that. Yes? No? Holy cow, law is really failing here, isn't it? You may be the only person left standing at the end of this discussion. Okay, now the institutional question. institutionally, what's worth doing here?
If I could actually jump in.
Yeah.
I think as a point of clarification to respond to Ms. Spiegel, I did not actually say that the financial markets align the interests of creditors with lenders for long-term growth. I agree with you that's incredibly short-term, which is why I was careful to say that creditors have an interest in a state not being debilitated, meaning destroyed. I didn't say they have an interest in long-term growth, but I think it's an important normative question as to whether or not creditors should be concerned with that. I think you made a statement, how do we write that debt down, unquote. And I think the precedent question is there a normative compelling reason to write that debt down? Now, the answer may well be yes, but I think that needs discussion. And I can think of at least a number of normative reasons why you shouldn't, which is capital markets need to be insulated from disruption. There are market inefficiencies. But I'd like to turn to Professor Tarullo's question, which is the institutional question. I was intrigued by the notion of GDP growth-linked debt, and also the broader issue of corporate social responsibility. It seems to me the principal responsibility of a corporation or its officers is fiduciary to its shareholders to maximize shareholder value. I hope I don't come across as a neocon here. I really am not. But I think that at least this view at least needs to be aired and discussed. And then there is the practical question, which is if I was JP Morgan Chase and I knew that my debt under a GDP linked structure would be at greater risk and I would essentially be taking on additional risks which would otherwise be on the lender, why would I agree to that? Why wouldn't I prefer a debt structure which insulates me from that risk?
Go ahead, Shari.
Yeah, okay. In terms of the first point you made, how do you define, I think the question is, where do you define long-term? And where long-term ends versus. So I'm not thinking of long-term necessarily in the next 50 years or so, but the truth is that the capital markets tend to be very, very short-term, like really before the end of the year.
Right.
And so the thinking of, even when you're lending to an odious government, you're probably going to be able to, if we're talking about liquid capital markets for a second, leaving off the other issues, which include the bilateral issues, which are a different sort of story because you're forced into a longer term framework. But if you're thinking about the capital markets, then you're really thinking, even an odious debt situation, you can get out before, and you're planning to get out, before that becomes an issue of what do you do with the debt. So that's the first side, is that I think the real question is where do you define that? And we're not thinking long term. The capital markets tend to be very, very short-term oriented. The second, in terms of the inefficiencies that you brought up, I actually think that the problem is that the markets are inefficient now, and that if you don't have a way to write down debt, that's when you have inefficiencies. Because, and that's one of the big problems in the capital markets, even going back to your initial response of, well, rates are so low now, that who would have suspected this? We're in a situation where we're not sure that the capital markets are efficient. Maybe they shouldn't be this low. And that therefore, the situation is not efficient even for the borrowers. I'm not sure it's good for the borrowers for interest rates to be this low. And so I'm not sure it's good for the developing countries for us to have to get into a situation where rates are so low because countries are borrowing too much. And so going back to your question, the inefficiencies, it's really that without a way to write down debt, you're in an inefficient market because creditors are being paid excess returns, maybe not today, but over a long period of time, creditors are being paid for the risk of default. And if you don't have some write-down of debt, then you're in an inefficient market. And we see that to the extent that the sovereign debt asset class has been the best performing asset class over the past 20 years, or 30, since it was initiated in the beginning of the 1990s. It's performed so well, creditors have gotten a huge return for their risk. And it's completely, in a sense, a really inefficient market. And we've done a paper where we calculated, even on a risk, and from all sorts of different risk return aspects, from every aspect you can imagine, this has been a completely outperforming market, which is a sign of huge inefficiencies in the market. And so the problem is that without a way to write down debt, well, there are ways now, but whatever the situation is, that's what we are in a situation of inefficiencies there, not the other way around. It's good for the capital markets, for creditors to at times write down their debt. And the third question in terms of the GDP linked bonds, What was your question again?
Well, I'm just trying to understand why a creditor
Oh,
would agree to that.
right, okay. And to that extent, I think that the markets have not been very interested in it. And have been, and there are all sorts of reasons why. It's not necessarily true that there aren't benefits for the creditors in terms of, that we're getting far away from the odious debt topic. But so I'm not going to go into all the issues of what benefits there might be or not be in terms of diversification. There are some issues. And in terms of, another way to think about it is that forget about the market side for a second, whether that's going to happen or not. But what about the international financial institutions issuing GDP-linked bonds? And so what about the bilaterals issuing GDP-linked bonds? So particularly for these creditors who are not doing it necessarily for financial returns, would this be a way to augment whatever rules-based or institution-based that we might have, so that the debt automatically adjusts to the situations of whether the borrowing has been, on a broader sense, efficient or not?
Jim, you want to?
Yeah, just two quick things. One is, I don't necessarily propose this is my own idea, but I recount in my paper the Kremer-Jayachandran institution. And that does seem to accept the idea of the existence of a doctrine of odious debt or something that subsequently replaced it, that would be a basis for this institution that they propose creating, which would decide which debts get paid.
Although, if I recall David and Patrick's paper correctly, these guys don't actually give a definition.
Right.
So they say it would be great to have an institution which took care of this problem, but we're not going to define the problem.
But they think there should be an institution which would do it, and it's on the basis of something like odious debt. And just on this, writing off versus, or writing down versus complete renunciation, I think two things are at play here. One is that, supposedly, I mean, I learned this in law school and then again as a young lawyer on Wall Street, lenders, if they're sane, have been pricing from the outset to take account of risk. So the interest rate, if nothing else, on the loans that they make should take some account of that problem. And then, if even Richard Nixon was a Keynesian, in the long run, we're all dead. So the idea of stretch out, taking a haircut on the interest rate and a stretch out on the payment versus complete renunciation may, ultimately be irrelevant. That the effects are going to be the same over the long run as far as the creditors are concerned. But it does tie in, I think, to Anna's point about what the difference is between debt that's owed to private lenders and debt that's owed to governments. Because the absorption capacity and the lack of functional shareholders who can bring you to account for the bad loans that you've made makes a big difference there.
Does North Korea hold any private paper? I mean, do they owe money to any private creditors? Yes?
Yes, they do.
How much, Lee?
I don't recall,
But
it's a chunky number.
and do you know who the creditors are?
I don't.
All right, so is there anything else on any issue, actually, Anna, go
Just
ahead.
very, very quickly, it strikes me that the choice between institution or not institution is somewhat linked up with the definition of the problem. And what I mean by that is the regime versus loan themes, right? There's the blanket repudiationist movement and the kind of micro-parsing movement. And I think if you go the micro-parsing route, look at every loan, figure out what it's for, et cetera, I think it's very hard to do it without an institution. I think that you're going to need, I think that sort of culturally comes from the idea of a judge looking at a loan, right? Whereas if you say, well, if your name starts with the letter D, all of your debt is bad, I think it's much easier to do without an institution.
Well, yeah, except that if you're having a rule, if you want to go the rule road, it doesn't solve the problem of what your institution is, right? You still have to answer that question. Is it domestic courts? Is it
You need
existing
an
international?
institution.
But at that point, you're trying to confine the discretion of the international institution. Okay, Kronenberg, sorry.
Yes, about North Korea. I think that Morgan Grenfell might be one of them, because some 20 years ago they tried to arrange a rescheduling or renegotiation of the debt, which was then turned down because it was a 70% cut, which was too much for the majority. Mm-hmm. And since the North Koreans have been regularly and reliably writing cards for the 1st of May but not paid, a lot of the debt must have remained in North Korea.
That may be, so let me open it up now to everybody, and you're no longer limited. Yeah, go ahead. Mark.
Thanks, Dan. Excuse me, just a comment about the notion of an institutional way of dealing with this. And please understand, I'm confining my remarks to the notion of establishing some new tribunal-like international institution. First point that I think applies not just in this area, but to any tribunal-like international institution, is that when such a body makes a mistake, when they make a ruling of law that outside observers will unanimously say is stupid, is wrong, it's very difficult to correct. It's not like a domestic institution where 50% plus one of the legislature can enact an amendment to a statute correcting a court's mistake. That's just sort of a cautionary point about tribunal-like international institutions anyway. Second point, more pragmatic, I've been sitting here asking myself why any of the governments which are themselves important lenders or whose national private creditors are important lenders would have any interest in creating any such international institution. It may well reflect my own lack of imagination, but while I can see why such an institution might benefit debtor states, it is less obvious to me why that institution would offer any inducements to either lending governments or governments whose nationals are lending.
If I can just introduce, Mark, that was actually one of the things that provoked my introductory comment on the sovereign debt problem writ large, because my recollection, I know this is true, most of the writing and advocacy on behalf of an international institution of some sort to deal with the sovereign debt issue writ large was written out of a position of sympathy with and concern for the debtor countries. No such institution has developed in the intervening years. The current advocacy for an international institution of this sort is dominantly from the creditor side, bleeding about the way creditors in the Argentine situation have been done dirt, and so there needs to be a way to hold countries to their obligations. So that it does strike me there's a certain indeterminacy to who finds the institution or rule useful or needed in a particular circumstance. Other questions? Yeah.
I'm just curious, but there seems to be this assumption that creditors have a uniform interest, and that is to have the debt repaid. That's not true in a world of CDS, right? With credit default swaps, I mean, from what I understand, at least in the court bankruptcy, the problem is you're talking to someone, you don't know what their economic interest is, right? The guy who has a lot of your debt could be net short. So, when you talk about interest of creditors, I'm just curious how the sort of financial innovations we see in the secondary markets for these loans affect some of our thinking about. So, like Shari talks about, let's link some notes to GDP. Well, that's fast. I'll lay off the risk. I'll just buy some CDS, and all of a sudden the problem reconfigures itself. And the same thing with Anna's thing. Again, all of a sudden you have people whose economic interests are different. So, I know it's messing up corporate bankruptcy because it's hard to do a deal when you don't know what someone's economic interest is. And I was just wondering how this stuff affects the sovereign debt.
You guys should both address this.
Oh, yeah, sure, go ahead. This just, it's purely factual, which is that the Venezuela, Ecuador, the rumor is that the stock of CDS written on Ecuador's debt is roughly equivalent, apparently, to the stock of Ecuador's debt outstanding. And the rumor is that Venezuela has written a huge chunk of those CDSs. So the way it'll come, so the price of the bonds themselves is going to spike when people are scrambling to get them to Venezuela. Venezuela is going to buy them from the capitalist running dogs at above market price and is going to hold them and is going to be presiding over the Ecuador restructuring. That is sort of a brave new world of official debt intermediated through the Mark?
Sorry, that might be a good thing because at least governments have non-financial interests, but what about when you have these other people buying the stuff up who are just creditors, right?
What about, I'm sorry?
No. In that story, right, your story is governments have different interests. So Venezuela might be doing this because Venezuela wants to bail out Ecuador, and Venezuela has political interest to do that, right? But what happens when you have a situation where it's just private creditors holding the CDS, and other people are trying to, the people who you think hold your bonds are trying to put you in, and so
Right.
forth,
Right, and you don't know until
Right.
the 11th hour when it all shakes out and who's going to sit at the table.
Right, I mean, I think that's a complication for how do you negotiate with your creditors when some of the creditors have interests that are against the other creditors because they're short instead of long. But net, when you think about every CDS as someone on both sides. And so.
But the question is, who is the voting
Right.
price for the bond? That's the
Right, no,
problem.
I understand, but net out there, there's positions that are long or short, that somebody's long, and so someone has the interest of.
But may not have the ability to write down the bond, right?
Right, they may not be at the table,
Tell
that's,
the
right.
CDS.
Yeah, no, of course, yeah, that's just an
That's the
issue for, in general, how do you negotiate with your creditors when you don't know whose positions are? And that's been a mess in some of the negotiations.
I have a footnote question, actually, to Shari, but we're sort of close to it, so I feel I can ask it. It's a digression.
David, don't give your paper.
I won't. I've been carefully not saying it. I'm not sure if I'm going to give it in the next panel either, but then I'm supposed to. Shari, you were talking about the inefficiencies of the market and the need for a way to write down debt. Do you have reason to believe those two are linked? Is the difficulty of writing down debt why the markets are inefficient, or sort of how do those two things fit together?
I feel bad because we're taking the topic so far from odious debt to the general.
But I think it's interesting that we've done so.
Right. You go for it. Okay, in that, I personally do. So, yeah, I personally think that there is a link between the two. That the difficulty in writing down, and I'm sure people in this room will completely disagree with me, but that the difficulty in writing down, or the structure we have for how debt is written down, is part of the reason why the pricing is inefficient. When you look at how Wall Street prices the bonds, the recovery value on bonds is usually priced at, I actually forget the percentage now, but it's much below what the actual recoveries have been on restructurings. And so when you look at, you have the probability of default, and which has, in the past years, you've actually seen more restructurings than in most of the 90s. And then you have what's the recovery value on those bonds. And the market has traditionally looked at recovery values. I don't remember the percent, so I don't want to say anything, but it's much, much below what the actual recoveries have been on bonds. And so I think that part of the way restructuring happens is not correctly priced into the market, and that's probably because there's so much uncertainty as to that recovery, what that recovery is going to look like. And so given that huge uncertainty, and about what recovery looks like, that when you have huge information imperfections, that's when you lead to more imperfections in the market. And so that's. Well, no, I think.
Because you would apply higher spreads because you have lower recovery rates on the debt.
Right, but I think that they have now because of excess liquidity. I mean, markets are very complicated, so when you have huge excess liquidity, that could override. You have different factors leading to tightenings of spreads and widening of spreads, and at the same time you have.
Why don't you just say that that's bringing it toward efficient, that basically.
Well, I think that unfortunately right now it's just that there's a huge liquidity in the market that's leading to this, and that the real issue is that you end up with huge volatility when you have huge inefficiencies. And so what we really see is more volatility in the market rather than which way the spreads are going to go. Because markets have things that push factors, which one outweighs at any point in time depends on what's happening in the market at that time.
It does, just two observations. It does seem to me interesting. Shari said she felt bad that we were getting so far away from odious debt, but it kind of confirmed, or at least it's supporting evidence for one of possible answer to the question I asked at the beginning as to whether we're really talking about, we end up very quickly talking about the larger issue of debt in its various manifestations. Second point, Shari, and this is getting even further still, but it does seem to me that the observation about spreads feeds directly into your observation about inefficiency of markets and failure to price in actual risk, but it goes way beyond sovereign lending, right? I mean, the compression of spreads is something that has affected virtually everything we used to think about as high yield, high risk. And junk corporate spreads are just as far down. So there's this, Anna and I were at a little, I can't resist this, Anna. I mean, we were at this little group in Washington that was talking, we weren't even talking about sovereign stuff, we were talking about corporates. Yeah, we were talking about something different. And there were a bunch of guys from hedge funds there, and no names now because we're on the record here. And people are talking about, spread and risk, and aren't you worried, don't you think you don't have enough risk and all the rest? And we just kept hearing everything was fine, and people understood perfectly where it all is, and of course risk was in there. And at one point, this guy, big private equity / hedge fund, next to me, turned and said to me, everything is completely fine, and it will be until the moment that it isn't. And that, I thought, sort of summed up where we are with capital markets right now. Okay, we probably have time for one more. Yes?
I just wanted to go back to the normative question. In his opening statements, Professor Feinerman, I hope I'm pronouncing it correctly, talked about the slippery slope. And this gentleman that left, that's the question about, why do creditor nations have an interest in this? And I think sort of rhetorically setting up the problem as one where, well, it's a political problem and all these nations are going to be wanting to justify and say that their debt is odious and bad and unjust, I think sort of puts creditor nations in a sort of like apolitical position where they get to do this if they're feeling sympathetic, which I think is somewhat problematic and probably not entirely accurate. It's not like lending is an apolitical thing. Often lending is done so for a political purpose, and with the strings that you're talking attached, those don't happen just in the renegotiations. Those often happen up front. So it seems to me that some of the political will to get this done could be mustered if it was somewhat rhetorically rephrased in the fact that not only do creditor nations need to feel sympathetic, but to some degree they might need to feel culpable for what happened under those odious regimes.
Anybody want to comment on that? Yeah, Jim. And
just one thing about the rhetorical point. I think it's interesting, and something that is sort of a footnote to my paper is the question of who's embraced the term odious now. And it's quite clear that it's been sort of captured by the global left or the anti-globalization forces. And it's very interesting that if you look, there's even a website called odiousdebt.org. But the groups and the institutions that use the terminology of odious debt seem to have a particular political take on this. And their interests are diametrically opposed to those of the creditor nations, which may explain one of the reasons why they'd rather use any other term to describe whatever the process is.
I think the point you raise, which ties into Anna's point about how when you're in a situation of state-to-state lending, there are political motivations. That's absolutely true. Foreign policy is never made based on sympathy, or hardly ever. And so that necessarily raises the question, and you raise the issue of culpability. Well, states are culpable to their citizens. Foreign policy is taken in the national interest, very rarely in the regional and even more rarely in the global interest. So there is an important and significant normative question, which, if I may propose, isn't that should we think of states as being culpable with a presumption that there should be some element of culpability, but more fundamentally, to who do states owe their interests, and how do they balance these conflicting interests in a responsible way?
And I would argue that not only are states responsible to their own systems, but they owe a degree of responsibility, even if it's a lesser degree, to citizens of other nations as well.
You know, I've surveyed numerous constitutions, haven't found it in any one of them.
Okay, Anna got the last comment initially, now she gets the last word before we end the session.
Yikes, what a wait. On this very point, the people who have now glommed on to IFI and bilateral conditionality are the human rights groups. Those are the people who are pushing for conditions relating to human rights, labor rights, female genital mutilation on IMF loans, and those are the folks who are like, wait a second, if you're going to write off these loans, you better put in all of these governance conditions, which are in effect displacing the domestic governance capacity in favor of some combination of Rumsfeld and Oxfam. So we're done.
Talk about your note on which to end. Okay, so we're 15 minutes, right? So we're going to reconvene at 10:45.
Oh.